in re estate of Thomas Lee Griffin.
I suppose we saved the best for last. Or not.
Well, I left my toothpaste at home, so I'm not worried about spilling it on the internet.
Well, you know, I feel required to say that because sometimes in the heat of the argument up here, people tend to blurt out things that they don't really intend to and wish they didn't later on. So
Yeah,
you
I
just
understand.
never know.
I think I understand the rules, and it's good to see all of you again.
Yes, sir.
I'm Alan Wade. I represent the appellant, David Griffin Sr., and I'd like to reserve 5 minutes for
5 years.
5 years, yes, sir. I don't think I will need it, but I'll reserve it anyway.
You may proceed.
Thank you, Your Honor. The facts of this case are pretty simple. It involves 3 parties, Thomas Griffin, who was survived by his 2 sons, David Griffin Sr. and the appellee. In this case, it's all about a piece of property in Arlington, Tennessee that Mr. Griffin acquired in 1992. And in 1998, he executed a quitclaim deed transferring an undivided 1/2 ownership interest in the property to David Griffin, which is the appellant. The deed was prepared by an attorney, William Maxwell, who is a longstanding and well-respected real estate lawyer, using a pre-printed form. And the deed was recorded, and a copy of the deed is attached to the petition. Mr. Thomas Griffin died in 2012. The appellee petitioned the probate court to open an administration, and at the same time filed a petition for declaratory judgment as to the validity of the deed. After that petition was filed, the appellant filed a motion for summary judgment, properly documented, essentially asserting that the property passed to the appellant by operation of law based on language in the quitclaim deed. And that language followed, in the deed, basically, the decedent deeded a half interest, undivided half interest in the property to appellant. And in the deed, after the property description, it contained the following language. It is the intention of grantor and grantee by this conveyance to create a joint tenancy with right of survivorship. It was appellant's contention in his motion that this language was sufficient to create a survivorship interest in favor of him, and as a result, on the death of Thomas Griffin, he acquired 100% ownership in the property. The motion was not responded to by appellee. The case came to be heard, the motion came to be heard, and at that time, the trial court ruled that he believed that because the granting language in the deed, which is the first paragraph of the printed form, did not deed the property to both of them and did not specify in that document a grant of a survivorship interest, that it was, there was no survivorship created, and that as a result, the property passed. My client owned 1/2 already, and the other half passed to the 2 of them as tenants in common, which meant the appellant had a 1/4 and my client had 3/4 undivided interest. We filed a timely appeal to this court and essentially are arguing that the court won its position that the language in the deed could be disregarded because it wasn't in the proper place in the deed, we submit is totally contrary to Tennessee law. And I think all of this law in terms of property was summarized in a case before the Tennessee Supreme Court, Bryant v. Bryant, in an opinion written by Justice Holly Kirby. She points out that in construing a deed, a court's primary goal is to ascertain the grantor's intent from the words of the deed as a whole. This is long-standing law, and it always has been the rule in Tennessee. We also cite the Dalton v. Eller case, which basically debunks the trial court's position by saying that we've long since discarded the technicalities of language in a deed being in the wrong place. You look at the total instrument to determine the intent of the grantor. And the primary goal of the trial court is to determine the grantor's intent from the words of the deed. And so what I'd like to do, and in this case, I'm not sure I really understand Appellee's argument. I mean, basically, they say that the language in the deed was not sufficient to create a survivorship interest. That's all they say. That is a conclusory statement. They don't give any analysis. They do not apply any of the technical rules of construction that would ordinarily be used to ascertain that. So in order for me to crystallize what my argument is today, I want to do something that the trial court didn't do and the appellee didn't do. I want to look at the words that were used by the grantor. And we submit that those words are not ambiguous. There was never any assertion that they were ambiguous and that they should be enforced as written. And the primary language that we're looking at is after the legal description, which says it is the intention of the grantor and the grantee by this conveyance to create a joint tenancy with right of survivorship. All right, so based on that language, I mean, obviously, if it's in the wrong place and that argument prevails, it's irrelevant. But I don't believe that courts disregard the intention that's clearly expressed by a grantor in a deed. So undeniably, this language says it is the intention of the grantor and the grantee. The grantor owned the property. He signed the deed. Clearly, he's expressing his intent. And it says by this conveyance, which means by this deed, we are creating a joint tenancy with right of survivorship. So, I mean, and I don't want to insult the court's intelligence, but I do want to just drill down and get down to the basics. Create, what does that mean? That means bring something into existence. So the grantor was intending to bring an estate in real estate into existence. And that was to create a joint tenancy. Now, we do know, based on Bryant, what a joint tenancy is. A joint tenancy is an estate that is owned jointly by two parties. There were a number of different common law distinctions about what is a joint tenancy and a tenants in common. It is undisputed that a tenants in common was created. But Bryant also points out that even if it is a joint tenancy or a tenants in common, the grantor has the right to attach to that a right of survivorship. So what happened here? He creates a joint tenancy, which we know is joint ownership. And he uses the word with. What does that mean? It means that it is accompanying another thing. So he is accompanying the joint tenancy with a right of survivorship. He's doing exactly what the court in Bryant said you could do, is attach a right of survivorship to a jointly owned property interest. And
Let me ask you, Mr. Wade, Could he have done that, could the attorney have done that in the granting clause? Just conveyed the property to Thomas and David as tenants in common with right of survivorship, and you wouldn't need any other language at all on the deed itself, would you?
No, and as you know, in a printed form, you don't have a whole lot of room to do that. What is the standard practice is to put it in the body of the document, and sometimes we attach an exhibit that expresses the right of survivorship to make it absolutely clear. I've seen where people interlineate survivorship. I mean, it creates a lot of ambiguity. I think they were trying to be clear and follow what the law was. So yes, you could have, but in a printed form, as you know, that's the form of a deed is prescribed by statute, and people use the printed forms to make sure that it is uniformly applicable and follows the statutory rules.
Okay.
And I believe my time is up. But that's essentially what I argue.
Good afternoon.
Good afternoon.
My name is Scott Vincent from the Memphis Bar, and I'm here for the appellee. I don't have a whole lot of extra to say other than what's already been put into the briefs. I also feel like I would be a little bit disingenuous if I didn't point out that the trial court, perhaps in drafting what we consider to be a well-thought order, also included a paragraph at the very end where he said that he invited an appeal of this order so that the appellate courts could take a look at what sort of language might be useful or necessary in order to create a right of survivorship in a deed. I don't disagree with a lot of what Mr. Wade said about I don't disagree with anything in terms of the overall history of this case. It's extraordinarily simple. I could probably, in my 15 minutes, actually stand up here and read y'all the entirety of the record in both briefs I wanted to, so I'm not going to do that, though.
Well, tell me this, how do you distinguish Runyon from the facts of this case?
The Runyon case?
Yes.
So that case just states that the goal of deed interpretation is to ascertain a party's intention. The problem with that case, I'm sorry, that's Dalton. The Runyon case was actually, if you read our brief, that case involved a number of different potential conveyances, primarily between a husband and a wife as tenancy by the entireties. It wasn't a straightforward right of survivorship case. There was a lot of language that was sort of disallowed by the trial court. I don't think that deed is the same deed, and I think that's the problem with some of these cases that we're dealing with, including the
Well,
Brown.
in the deed in Runyon, he owned, the decedent owned the property,
Right.
and he conveyed to the wife, as in this case, a 1/2 undivided interest. And then later in the deed itself, but not in the granting clause, he didn't create the right of survivorship. There's language below that, just like in this case. And then the trial court interpreted that to create a joint tenancy with right of survivorship. So why is that case different from this case?
In my opinion, that case is different. That case is different from this case because of the specific language of the deed, which also included, if I recall, a grant to heirs. It created a number of different scenarios, but I believe that the trial court in that particular case was more, or the appellate court was more held up on the tenancy by the entireties aspect of it. And what they did was they read, there were so many different ways that there was an intention of that particular grantor to convey it with a right of survivorship. They found one. I would submit that in this case, really what we're talking about is a Bryant deed. I think that case is on point. And I think the problem is that what Bryant has told us is that if you're going to establish a right of survivorship in our current language that we use in deeds, what you're supposed to do is actually convey it to yourself and to the other party and state specifically that you're conveying it jointly with a right of survivorship.
But that's not what happened in Runyon.
That's true.
It wasn't conveyed to the grantor and the grantee, the whole thing. It just granted a 1/2 undivided interest as it did in this case.
I can't tell you that that's a distinction without meaning. And what I mean by that is that I understand what you're saying, and I think that the case law is a little bit incompatible, in my opinion, as to what you actually have to do in a deed in modern practice where we aren't using pre-printed forms.
So are you saying that's fatal in this situation?
Which part? That's a
The
pre-printed
fact-
form?
The fact that he did not convey it to himself and his son.
I think it is further indication of a lack of intent of the grantor to have actually granted it with a right of survivorship. I understand what's in the deed. I get that. Again, I'm not intending to come up here and say that I don't get what's in the deed. I think the trial court had a very detailed and thoughtful analysis of what the deed intended. And in doing this, and we also have this in our brief, there's also Tennessee property law out there that says that you can't divest a grantor of a greater amount of an interest in property than what was intended by the grantor. And we cited that for the reason that it's our opinion that if you only look at that sentence, the sentence that's in the conveyance and on the granting clause, and you don't at least consider what's in the granting clause, you're picking one over the other. There's a tendency there's a tendency in common in the granting clause. And then there's a right of survivorship language down below that. That language also includes a statement that it's the intention of the grantor and the grantee. The grantee is not on the deed. The grantor didn't convey it to himself. It almost looks like that language was just stuck in there. Maybe it's from a form, I don't know. But at best, we've probably got poor draftsmanship from 1998. And the trial court was stuck with the position of trying to decide, whenever you look at these two different paragraphs that say two different things, what do you think that means? And I believe the trial court properly applied property law overall, not to divest a greater interest than what could be clearly told by looking at the deed itself.
Can't you read the deed so that it doesn't say two different things?
I don't know that you can.
Well, let's start with the first proposition.
Sure.
Even assuming that there's a problem with not conveying it to himself and his son. He's conveying to his son a 1/2 interest.
Yes, sir.
Correct?
Correct.
Then you've got the secondary language that says, and I'm creating a survivorship interest. So consequently, it would pass to the son anyway if you look at it consistently, right?
Well, does that create? No, I don't believe it does. I think that at that point, you've got a 1/2 interest that you're talking about. And while it seems extraordinarily
Well,
redundant.
you've got a 1/2 interest that he's conveyed to the son.
I agree.
But if you also add in, I'm creating a survivorship interest, then it all goes to the son anyway, doesn't it?
I don't think so.
And why?
I think because if you look at Bryant, and again, I'm applying the case law that the Tennessee Supreme Court has given us whenever we're talking about the entire, Bryant's a good primer on property law and the entire history of deeds in Tennessee. And I believe that the Bryant case establishes the standard for what has to be in the deed, which is why I think the trial court was focused on the granting section. In the Bryant case, the deed was a conveyance of the grantor to himself and the other party with a right of survivorship. That was in the granting section, and there were two different people getting that piece of property, including the grantor himself, or herself in that case. I believe that's absent here, and I think that is a distinction with meaning. I think that is what the standard is.
But Bryant really just tells us you look at the entire deed to determine intent. But actually what happened, Bryant really is for the proposition that unless you have a tenancy by the entirety, that one individual can sever a joint interest.
That's right.
That's what it really stands for, other than you look at the entire document to determine what the parties intended. But it doesn't support your argument here that the trial court got it right.
Well, I also don't think it's fatal to my argument that Mr. Wade's client's wrong. I think the Bryant case does establish we know what a conveyance with a right of survivorship looks like from Bryant, at least in the Tennessee Supreme Court's mind. Does that mean that everyone has to be the same? I don't think it does. But I don't think that this deed fits into the parameters of what that is. I think we have two different deed sections is what we've got, and the court was challenged with which section do I look at in determining what goes to whom. And
So-
I'm sorry.
Go ahead. You
No, I
can
was-
finish your sentence.
I was just going to say that it's our opinion that the court got it right, but I also understand why the court has invited this court to look at this.
Well, so if I'm understanding what your line of reasoning here, or your argument, your only basic problem with this deed is in the actual identification of the grantees, as opposed to the Bryant situation. The Bryant, because the language is almost identical to Bryant in the sentence that follows, that's creating the joint, that it is the, just let me read from the deed. It's the intention of grantor and grantee by this conveyance to create a joint tenancy with right of survivorship. That language is very similar to the Bryant language that was used. So your distinction here is just that this was conveyed only to one individual, the son, as opposed to conveyed to the father and the son together.
Correct, and I also would, and if I may, I'll read exactly what the Bryant case has got. This is what it said, and this was in the granting clause. I, Molly Bryant, a widow, have this day bargained and sold and do hereby transfer and convey into Molly Bryant and Darrell Bryant, Sr., for the purpose of creating a joint tenancy with right of survivorship, all my estate, right, title, interest, and claim in and to the property. That's not in this deed. Perhaps what's in the other deed is sufficient, and that's what this court will ultimately hold, but this is the primary case that appellant relies upon, and actually stated in the brief that we have basically the same language from the two deeds. I do not believe that's the case. We have a granting clause that established a tenants in common, and then we have a statement later on in the actual description that includes survivorship language. I find that to be troubling, and I wish that wasn't in there. That's the reason why we're here. But I believe that the trial court correctly made the determination that there was more of a limited grant than what that one sentence said.
In the Runyon case, which is also a Tennessee Supreme Court case, the conveyance was not to the grantor and the grantee.
Understand.
It only granted a one-half undivided interest with later language in the deed, just as in this case, but is my intent to create a joint tenancy with right of survivorship. And the Supreme Court said you look at that language in determining what happens upon the death of the grantor. And in that case, it created a survivorship in the entire fee, in that case, to the wife.
And again, I would submit that the Runyon's case is a 1948 case. Whenever the Tennessee Supreme Court was still, I would submit, in the middle of its determination as to what constitutes language of antiquities and what constitutes more up-to-date language for purposes of deeds.
So we should disregard it just because it's a 1948 case?
No, of course not. But I think that Bryant establishes, for purposes of this type of a deed, which is not, again, Runyon's involved a husband and a wife, and I think the Supreme Court was held up on what survivorship language was necessary in that context. That's not the context here, and Bryant wasn't that context either. And I believe the Bryant deed is the appropriate deed, the language to use. I believe that appellant, but for this discussion we're having right now, had up until this point thought the same thing, because that's the case that's primarily relied upon them.
So you think because it was the grantee in Union was a wife, and here it's a son, that the outcome should be different?
I think it arguably should be, yes, because there was an intention in that deed, if I recall, to initially grant a survivorship interest by the entireties, which only happens in the context of a husband and wife relationship. But the court ultimately found survivorship language by looking at a number of different scenarios, including a grant to heirs.
But in reunion, in the language below the granting clause, there was no mention of a tenancy by the entireties, was there?
No, there was in the above clause, I believe.
I don't think so. I think just as in here, it said an undivided one-half interest in another party.
It says, if I could, and I'm reading from Appley's brief on page 15, in the block quote at the bottom of the page. Immediately following the description and immediately preceding the habendum, there appears to be in the deed to his wife this language. It is intended to convey the property herein described so that it will hold the same as tenancy by the entireties.
That's after the,
That's my understanding. I don't have the deed in front of me. I'm reading from the case. So again, I would submit that that particular situation is different because we're talking about a different type of joint tenancy, not with the right of survivorship. Long ago, right of survivorship was more of the default setting. Tennessee has for a very long time decided that's not the default setting anymore, and there's a presumption against it unless there's a clear statement of intention by the grantor. I understand appellant's argument that the sentence in the conveyance or in the actual description is that sentence. I would submit that you have to read the entirety of it, which includes language that suggests in that survivorship language that the grantee is somehow part of that deed, which the grantee isn't. The grantee didn't sign anything. It almost looks like a form that just got stuck in there. And I think the trial court was correct in this case.
Well, it's all a form, isn't it? They're using a form deed and filling in blanks.
Well, we don't use forms to fill in blanks for our deeds.
I know a lot of attorneys who don't use forms, but the ones that do, this is pretty much what they're confined to, is it not?
It is if that's what you choose to be confined to. Again, as we put in our deed, I believe that poor draftsmanship may have played into this, but that's why we're here.
So are you arguing that the Bryant case says anywhere in it, because I didn't see this in Bryant, but are you arguing that it says that there must be a dual grantee?
No, I'm not
That the
arguing.
grantor must
No.
also be a grantee?
I do not believe that. I don't have the authority to say it should be. I think that if you're looking at clear intention, that's a best practice. I don't know that the law requires it, and I don't think Bryant says that. My position is that to the extent appellant is taking the position that the deeds are virtually the same, they're not.
Thank you.
Thank you.
Thank you.
Thank you. Let's clarify a couple of things. The grant to David Stephen Griffin was an undivided one-half interest. The law is that you have a joint tenancy or tenancy by entirety where the unities of interest, title, time, and possession exist at the time of conveyance. In Bryant, in Runyon's, and in this case, the grantor owned the property and therefore deeded it after. So it's irrelevant whether you use a conveyance to the grantor and the grantee, or you use what was done here, an undivided one-half ownership interest into the property. In that case, you are creating a joint ownership. And then the key language below attaches to that joint ownership. That's what's referenced in this deed, the right of survivorship. That is the crux of the case. In
About
Bryant,
opposing counsel's argument that it also binds the grantee, but the grantee didn't sign the deed.
well, that would only be the case if the grantee predeceased the grantor, and his heirs were making that argument. That argument is, they've got it backwards. In this case, the party to be charged is the grantor, and he clearly says, I am attaching to what I own and what I retained and what you got, a right of survivorship. And remember, when you jointly own property as tenants in common or joint tenants with, well, there's no longer a joint tenants with right of survivorship. As Justice Kirby points out, those two estates are indistinguishable now because the statute took the common law right of survivorship away from joint tenancy. So this language is really attaching the right of survivorship to a joint ownership by two or more parties. That is clearly allowed. Runyon's, if you read Runyon's did not create a tenancy by the entirety because they did not acquire the property at the same time, the same title. Later, he deeds it to his wife, and the holding is it didn't create a tenancy by the entirety, but a joint tenants with right of survivorship, which is distinguishable because a tenants by the entirety has the fifth unity, which is coverture or marriage. That is a whole different estate, as Brian talks about, because they own the whole, and you cannot sever it. You cannot do any of the things you can do with these other joint tenancies. So it didn't make any difference that they were married. Runyon's, we submit, is exactly where we are. What was created here was an undivided interest in the property in both the grantor and the grantee. They both had equal rights to possession. They had equal rights to everything. And what he did was attached the right of survivorship, as Bryant points out, is long-standing law in Tennessee, to that joint tenancy. Joint tenancy is used here for a reason. He was not attaching it to any particular interest, but to the entire fee. And we submit that's the only way you can read this language. And again, Runyon's talks about you try to give the result as near as possible to what you gleaned was the intention of the parties. I don't know how you can read this language and say, the grantor signed this and saying, it is my intention by this conveyance to create a joint tenancy with right of survivorship. I don't know if I can say it 100 different times. That's what was intended, and I think that's what the result should be. Thank you very much for your time.
Thank you, counsel. We appreciate your argument. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. You're excused.